and I had 20 conversations, decent conversations with constituents of mine. This is rural Norfolk. 19 of those 20 conversations raised illegal migration as one of the key issues. That is the reality of the views of the people who I represent, and we would be mad in this House if we did not accurately reflect those views. My final intervention.
Sir Roger, I'm grateful to my honourable friend for giving way. Would he join me in paying tribute to the work of the East of England Local Government Association and the East of England Strategic Migration Partnership, who've done such amazing work supporting the resettlement of British passport holders from Hong Kong, Syrians coming through the Syrian resettlement scheme, through Homes for Ukraine? And does he agree with me that it'd be much more acceptable to those constituencies referred to hear that those individuals have come to the UK through arrangements agreed with local authorities who have the capacity to support them, rather than, as I witnessed when I visited the jungle camp in Calais, done by a rate sheet of smugglers? The more you can pay, the more likely you are to be able to break into the UK through a back door.
My honourable friend is exactly right. That my constituents are generous-minded, they are welcoming, but they don't like the unfairness. They feel that this is inherently unfair. So we've got young men aged 18 to 40 typically. Where are the women? Where are the children? We've got young men 18 to 40 who are relatively rich because they've been able to pay £3,000 to £5,000 to the smugglers, or worse still, will be indented and end up in slave labour trying to pay back a debt that will never be repaid. You've got, this is a terrible situation which needs to be addressed. Now, the government has taken really effective action, and we can see that, not because I just say it, but because in the hard data that we've seen this in the last year. In a time when migration into the European Union is going up by about a third, and in Mediterranean companies by fully 80% last year, the effect of the suite of interventions that the government has already made has been so effective that it has reduced migration down in this country by 36%, over a third. That's not because of Rwanda, it's in addition to Rwanda. It's because we've increased French patrols on the coast by 40%. It's because we've been tracking down boat supply in places like Romania and removing that production from the ability of these gangs to physically get people across the channel. We've increased the raids on illegal workplaces, which were part of the pull factor for the illegal migrants. And perhaps more importantly than anything else, we have cut a deal with Albania, demonstrating that where the year before, I think about 20,000 people came from Albania, claimed asylum, with the returns policy, recognising that Albania is a safe country, just as Rwanda is, by the way, that the number of potential migrants coming across the channel has decreased by in excess of 90%. So if we need an example of why the Rwanda policy should work, look at Albania. Look at the results that we have already achieved, and this government, for who, I commend them for the hard work, the hard yards, the incremental gains, which have shown, we're not all the way there, but 36% reductions already and counting. And if we add on what we propose in this bill for the Rwanda relocation deterrence, I think this is going to really make an enormous difference. And we've heard from government lawyers that the current process is likely to reduce the number of appeals by 99.5%. Yes, there may be the odd one who continues to appeal, but that last-minute process of repeated appeals, that will be removed. And that's why I don't feel the necessity to support the proposed amendments in this bill, and I will be supporting the government.
Michael Thomas.
Sir Roger, thank you very much indeed. With your permission, may I, on behalf of His Majesty's Government, pass on my sincere condolences to the family and friends of Sir Tony Lloyd, the former Member of Parliament for...
Order. I'm sorry to have to interrupt on such a sensitive issue, but Mr. Speaker intends to make a statement about that later.
I'm very grateful indeed for that guidance, and thank you for that. May I start, therefore, by turning to those who have contributed during the course of this debate. May I start with my honourable friend, the member for East Worthing and Shoreham, thanking him for his powerful points, his challenging, forensic, learned even points that he made. He once again questioned what solutions are being offered by the party opposite. He's right to do so. Answer came there none. May I thank my right honourable friend, the member for South Holland and the Deepings. As so often, he debates in poetry, and I'm going to come back to some of the remarks he made in due course. May I also thank the Chairman of the Select Committee, the right honourable member for Kingston upon Hull North. She was right, and she ensured she didn't make a second reading speech, but she did mention one or two other matters and amendments, and I'll turn to those in due course. I thank my honourable friend, the member for Ruislip, Norwood and Pinner, always thoughtful, measured, and so often right, and I'm grateful to him for his contributions and also for his interventions during the course of the latter stages of this debate. The honourable member for Glasgow Central cited Robert Burns and asked what he would have to say to the benches opposite. And my honourable friend and neighbour, the member for North Dorset, rather cheekily from a sedentary position, suggested that Robert Burns might say to the benches opposite, "How can I join you?" That wasn't the gist or the thrust of her speech, but it was a cheeky intervention that I enjoyed nonetheless. I'll turn to her amendments in due course. My honourable friend, the member for Don Valley, I listened carefully, as I always do, and I hope to be able to turn to some of the points that he made and hopefully allay some of the fears that he has. He said that it sometimes happens that the chamber empties or isn't as full when he speaks. It sometimes happens to ministers as well, but not everyone is back when the minister is responding to their contributions. But he is here, and he is in his seat, and I'm grateful to him for sitting through so much of this debate and also for his characteristic courtesy. My honourable friend, the member for Ipswich, spoke with passion, as he always does, and I'm grateful to him for his contribution. My honourable friend, the member for the Isle of Wight, again spoke at some length. I'm grateful to him for that. He delved into the principles of the ECHR, and he was enticed by my right honourable and learned friend to make some pronouncements on some of those judgments. And I thought that was a little bit mean of my right honourable and learned friend, the member for South Swindon. But he did at least proffer one suggestion, namely the case of Hurst, and I'm grateful to him for that. My honourable friend, the member for Broadland, again, I'm grateful to him for his intervention and for being on duty not only in Westminster Hall, but also here in this chamber. Sir Roger, the course of this debate has been constructive. On the whole, I agree. It has been broadly thoughtful, instructive. We've had references to scripture. We've had an exchange on that. And as a lawyer, it was a joy indeed to hear the word otios. And we didn't hear it once. We didn't hear it twice. We heard it several times. We once even heard otios with bells on, from my honourable friend, the member for Bromley and Chislehurst, and I'm grateful to him for that. I've not heard that expression before, but I feel sure that it is a legal reference that I must have brushed past in my youth. We've also heard about box sets. We heard that from my right honourable friend, the member for Newark. We heard about that from the honourable gentleman, the member for Glasgow North, and I'll need to do a bit more research on that, I think. And we also touched on ECHR membership, although rightly, my right honourable friend, the member for Newark, said this was not the place to have that full debate. But he set out some of the parameters for the future debates that I'm sure we will have. Sir Roger, may I turn firstly, please, to Clause 1. This clause sets out the rationale of the bill. It sets out the legal obligations and how the treaty to which the government of Rwanda have agreed addresses the concerns that were set out by the Supreme Court. Amendments 39, Amendments 40, 41 and 42, tabled by the honourable member for Glasgow Central. We heard her address those points. And also Amendments 43 and 44, tabled by the honourable member for Aberdeen South. They seek to exclude the core of these provisions. And once again, the honourable member was very clear about her intention in that regard. But the treaty is binding in international law. In accordance with Rwandan law, the treaty will become domestic law in Rwanda on ratification. And, Sir Roger, that's set out in detail and it's confirmed in Article 3(6) of the treaty. It rules out anyone relocated to Rwanda being removed from there, except to the United Kingdom. That is an important part of the treaty set out in Article 10(3). And this is regardless of whether the individual is found to be a refugee or to have another humanitarian protection need. This removes the risk of refoulement. Everyone relocated to Rwanda will receive the same treatment. Those with refugee status, those with a humanitarian protection need, or even without that status, will be able to stay in Rwanda and receive the same rights and treatment. This addresses head-on the concern that the Supreme Court set out. The asylum decision-making process is being significantly reformed. An Annex B of the treaty, and if I have time, I might turn to the details of that in due course, but Annex B contains strengthened monitoring arrangements to ensure, and there are also strengthened monitoring arrangements to ensure adherence to the obligations. I'm very grateful indeed to my right honourable and learned friend, the member for Kenilworth and Southern. I'm very grateful for his engagement. I don't believe that his concerns are right. He said offensive or otiose. I would suggest neither is right, and I hope to be able to reassure him with what I say now, because Clause 1 makes clear that Parliament is sovereign and that its acts are valid notwithstanding any interpretation of international law. And he will understand that I'll come back to that notwithstanding terminology that has been so contentious, perhaps, in recent history. But what it doesn't mean is that doing so legislates away our international obligations. The purpose of the bill is to say that on the basis of the treaty and the evidence before it, Parliament believes that those obligations have been met. It doesn't mean that we do not care whether or not they have been met. He mentioned dualism. He was right to do so. The parts of this clause to which my right honourable and learned friends' amendments are directed, they do no more than make clear what we mean by a safe country, which is a key definition applied to Rwanda, namely that the United Kingdom can remove to that country in compliance with its international obligations, and that Rwanda will not remove anyone in breach of any international law. My right honourable and learned friend also mentioned, as a former Attorney General, the Law Officers Convention. I was very grateful to him for that, for so often in this chamber it goes unnoticed. It is an important convention, and as a former law officer myself, I abide by it very strictly, as I know he does as well, and I'm grateful to him for reminding the House of that fact. May I turn to the amendments tabled and the speech of my right honourable and learned friend, the member for South Swindon. I'm grateful again to him for his contributions, not just yesterday, but today as well. It's important that the will of Parliament is made clear, and that following the mammoth efforts between our government and the government of Rwanda, the obligations that we have agreed are fully set out. This clause, Clause 1, ensures that it's crystal clear that it's Parliament that has considered and concluded that Rwanda is a safe country. I know my right honourable friend's concern about this sort of clause. He will know that it's not unique and that it's not dissimilar to the Illegal Migration Act and the Clause 1 that was there as well. And I suspect he's encouraging me not to pray that in aid, but it is a fact all the same that it is there. It is not unprecedented to have a clause such as Clause 1 in the bill. May I turn, Sir Roger, please, to Clause 3. The United Kingdom has a long-standing tradition of ensuring that rights and liberties are protected domestically and of fulfilling our international human rights obligations. We remain committed to that position, and we will ensure that our laws continue to be fit for purpose and work for the people of the United Kingdom. Though some of the provisions in the bill are novel, the government is satisfied that the bill can be implemented in line with the Convention rights. However, it has been clear that people will seek to frustrate their removal by any means. Therefore, this bill goes further than the Illegal Migration Act taken through by my right honourable friends, the members for Newark and for Fareham. As we have heard, that bill only excludes Section 3, or one of the Human Rights Act, this bill and this clause any public disapplies further elements, including any court or tribunal that is taking a decision that's based on the duty under Section 6, 2 of the bill. One of the Human Rights Act is disapplied of Rwanda as safe. May I turn directly to my right honourable friend, the member for Newark, and for his amendments, firstly his amendments 11 and 18, if I may. The bill, he's right, does not seek to disapply Section 4. It does not, in fact, disapply the Declaration of Incompatibility provisions in Section 4. This is the only substantive remedy against the conclusive presumption that Rwanda is safe. Retaining declarations of incompatibility is important, but of course, the final say on this matter will remain rightly with Parliament and with the government, because of Section 4, subsection 6 of the Human Rights Act makes it clear that a declaration cannot affect the operation or the validity of domestic legislation. I will give way.
I think he makes a very important point there about the extent to which the courts should and can intervene on issues relating to the compatibility of primary legislation with the ECHR. The Section 4 procedure allows the courts to express a view, but doesn't trespass directly upon the functions of this place in order with dealing with the problem. It simply gives Parliament an opportunity to then rectify any situation, or not, frankly. Does he agree with me that Section 4 is a much better mechanism for the courts to use than the clunky and inelegant and sometimes very problematic Section 3 procedure?
Indeed, to my right honourable and learned friend, I heard what he said about Section 3 and I agree with him wholeheartedly and entirely. He's absolutely right to describe it as clunky, and it has been disapplied in this bill as well as the Illegal Migration Act. But may I say directly to my right honourable friend, the member for Newark, that I accept entirely his comments when he says that he is here to help the government, that he believes passionately in this policy, and he has had several very frank, open and honest conversations with me about that, both in this chamber and outside. I'm very grateful to him for the way that he put his points so ably and so clearly. But the disapplication of these sections within the bill significantly reduces the extent to which public authorities are bound to act as a consequence of the Convention rights. May I turn to some other amendments, Sir Roger? May I turn to Clause 5 and the further amendments tabled by my right honourable friend, because this bill makes clear in Clause 5 that it is only for a Minister of the Crown, and only they alone, to determine whether to comply with an interim measure of the Strasbourg courts. It also makes it clear that the domestic courts may not have regard to the existence of any interim measure when considering any any domestic application flowing from a decision to remove a person to Rwanda in accordance with the treaty. What happened with the Rwanda flight in June 2022 was frustrating, as many honourable members have mentioned. It was a deeply flawed process and raised issues of natural justice, but changes have been made since then, not least in the Illegal Migration Act. And since then, the Strasbourg Court has, on the 13th of November, announced the outcome of its review into the rules concerning interim measures. And the changes include the naming of judges, and that interim measures should be communicated as formal decisions. And it confirms the existing practice in parties being able to request reconsideration of a decision in the rules. And the United Kingdom has responded formally to that court's consultation. Sir Roger, I know that colleagues have raised concerns that, assuming this bill passes and succeeds in closing down the vast majority of individual claims, our deterrent will be frustrated by a Rule 39 interim measure. May I say directly to my right honourable and honourable friends that I understand those concerns. No one who was here in June 2022 and saw the last Rwanda plane left on the tarmac, can fail to understand the importance of fixing this issue. That is why the Prime Minister has been clear that he will not let a foreign court block these flights. We simply cannot let an international court dictate our border security and stop us from establishing a deterrent. And that is I must complete this point. I must complete this point. That is why we have inserted into clause 5 of this bill, which is crystal clear, that it is for ministers and ministers alone to decide whether to comply with Rule 39 injunctions. We would not have inserted clause 5 if we were not prepared to use it. And I can confirm to the House that we can and will lawfully use that power if the circumstances arise. The discretion is there. But we go further still, and we confirm that the civil service must implement any such decision. Today, the Permanent Secretary for the Home Office has confirmed that if we receive a Rule 39, instead of deferring removal immediately, as currently is the practice, officials will refer the Rule 39 to the Minister, not to be too grandiose, but Sir Roger, in this case to me, for an immediate decision. As the Cabinet Office has confirmed, that is the responsibility of civil servants under the Civil Service Code to deliver that decision. Sir Roger, colleagues have confirmation that we have the power, we would use the power, and the civil service will give effect to it. If a plane is sitting on that runway, this government will not stop until it takes off. And we all know what the opposition would do. They would campaign for it to be grounded. Will my honourable and right I will give way to my honourable friend.
Thanks, Sir Roger. I'm grateful to the Minister for giving way. With the point he's just referred to, he said that there will be circumstances in which we will ignore these pyjama injunctions. What are the circumstances of which the government will not ignore and therefore comply with them?
I couldn't have been clearer.
Now we gave you a breaking news. British Prime Minister Rishi Sunak is set to comfortably win a final vote in Parliament's lower house of Commons on his plan to send asylum seekers to Rwanda, as most rebels who favour a tougher approach are set to back the legislation. Our sources said. Our source, present at a meeting of lawmakers from Sunak's governing Conservative Party who have argued for tougher measures, said that most would vote to support the plan, with only a small number expected to rebel against the government.
Newark addresses that exact point about medical records and medical evidence. The following, Sir Roger, are examples of harm that do not constitute serious and irreversible harm, namely where the standard of healthcare available to the person in the relevant country is lower than that available in the United Kingdom. It is there. It is in the statute. It is in the bill that we passed last year. Any pain or distress resulting from a medical treatment that is available to a person in the United Kingdom not being available to a person in the relevant country is not, does not and will not constitute serious and irreversible harm. My right honourable and learned friend is right to be concerned about that, but those concerns have been addressed and have been met in the legislation that we have passed and in the legislation that is mirrored in this bill that we are taking through today. May I turn to Clause 8 and the important provisions that are there. And may I address directly, please, the Honourable Member for Belfast East and his submissions in response to new Clause 3. Nothing in the Windsor Framework, including Article 2 or the withdrawal agreement, affects the bill's proper operation on a UK-wide basis. Any suggestion to the contrary would be to imply that the scope of the Rights, Safeguards and Equality Opportunity chapter of the the Belfast Good Friday Agreement is far more expansive than was ever intended. I will not give way. We are unequivocal that that is simply not the case. And Article 2 of the Windsor Framework is not engaged. I would be happy to write further to the Honourable Gentleman and to the Right Honourable Member for Lagan Valley on this point to set out further detail. I hope I can reassure him that we have already achieved what the aim that he seeks. I will give way. He must be conscious that we are up against a very tight deadline.
On the statements he made with regard to Rule 39 and so forth, can he explain to the House how the government would be able to prevent a judicial review of the decision taken by the Minister without legislation?
My honourable friend has heard what I said on that point. I respect him and admire him. He knows the esteem that I have for him. We have a good faith disagreement on the effect of this. Clause 5 is clear. It is for a minister to decide, and a minister will decide. May I finish this point in response to the honourable member for Belfast East? I hope I can reassure him that we have already achieved the aim that he seeks. The bill will apply across the whole of the United Kingdom, in line with the application of our sovereign immigration policy across all 4 nations of the United Kingdom as a territorial whole. I am grateful to him for his kind and generous comments about me personally. I'm grateful to him for his engagement, and I will continue to engage with him on this issue. Sir Roger, we have made progress towards stopping the boats, with small boat crossings down by a third in 2023. But we must do more. The only way to do this is if it is abundantly clear that illegal entry will never lead to a new life in the United Kingdom. The power of deterrence is proven beyond reasonable doubt by the success of our agreement with Albania. Sir Roger, Parliament and the British people want an end to illegal immigration, and we need a deterrent. We have a plan. We have a plan to stop the boats, and I invite all honourable and right honourable members to back it.
Order. Amendment 11 has been proposed. Mr. Jenrick, do you wish to press it to a vote, or do you wish to withdraw it?
With your permission, I'd like to withdraw it, but if you are agreeable to press Amendment 23 instead.
We'll come to that in due course. Is it your pleasure that Amendment 11 be withdrawn?
Aye.
Amendment by leave withdrawn. Under the order of the House of the 12th of December, I must now put the questions necessary to bring the proceedings to a conclusion. The question is that Clause 3 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. Aye. Division, clear the lobbies.
British Prime Minister Rishi Sunak looked set to defeat a major rebellion in his own party on Wednesday over his plan to send asylum seekers to Rwanda after a majority of critics of his proposed law decided reluctantly to back the government. Sunak faced down the rebellion by right-wingers in his Conservative Party by offering only token compromises to those who demanded he toughen a new bill to tackle illegal immigration in moves centrists feared could breach human rights protections. In the end, after a meeting of the rebels, a source said the majority of those attending would fall into line and back the legislation in a final vote. Some worried if they voted against it could inadvertently collapse the government, with the Conservatives trailing the opposition Labour Party in the polls before this year's election. Some lawmakers were concerned about rejecting a plan voters might feel could reduce high immigration rates, a crucial issue for some Britons.